All right, everyone, thank you for attending our next session of the Angel NV Entrepreneur Bootcamp series. This session, we are going to have Jim Yee, who's going to be telling us and exploring, and we're going to explore intellectual property considerations such as intellectual property, patents, and trademarks, which I think other than raising capital and how to pitch, I think we get a ton of inquiries about intellectual property considerations or moats or trademarks in our ecosystem. So we're really happy to have James here to speak on that. But first, I'm going to introduce Jim. Jim's practice focuses on intellectual property law with a concentration in electrical, mechanical, electromechanical, computer architecture, systems, software technologies. In his 30 years of experience, Jim has written and or prosecuted thousands of patents in automotive and motor vehicle industries, computer and gaming fields, and more. Specifically, he has extensive experience in drafting and prosecuting patents for medical devices, software, customer loyalty programs, e-commerce systems, and building and construction systems. So without much further ado, Jim, please, the floor is yours. Fill in anything else that I left out there. Very thankful you could be with us today. And
thanks, Logan. Good evening, everybody. I can't really see how many people are here, but I hope everybody is enjoying the evening and not out in the traffic. And Logan, I did share my slides with Maggie. I sent them to Maggie just a minute ago, so please feel free to share them with everybody. As Logan mentioned, my name is Jim Yee. I am with a firm called Endurance Law Group, which is based in Michigan, but I work remotely here in Las Vegas. I have just a quick background. I do have close to 35 years of intellectual property experience. I have a Bachelor of Science in Electrical Engineering from Michigan Tech and my law degree from George Washington University in DC. I spent 13 years in the first part of my career working for 2 different companies, and then I was a partner in a mid-sized law firm, also based in Michigan, but has a good-sized office here in Las Vegas. For the last 2 years, I've been with a smaller firm, again, based in Michigan, but I work out here. So we're going to talk a little bit about the types of intellectual property. We're going to go over a couple of pitfalls that startups or small companies can face. And we're going to talk about, choosing a name for a company or products. And if we have time, we're going to run through a hypothetical of a new company and some of the intellectual property issues or how they can use intellectual property in their business. And then we're going to field some questions. And I'm not sure exactly where everybody is in terms of the development of the company. So I'm hoping I'm not going over stuff that everybody already knows. And if there's questions, please just put them in the chat and Logan will let me know that they're there. So again, just go back here, some of my representative clients over the years. I'll skim through this. And some of the technologies, these will be in the slides that will be made available. And some of the patents that I've worked with over the years. I've done a lot of gaming related work over the last 20 years. This is a company that that I developed a patent portfolio in electronic gaming space. It was bought by Multimedia Games, the company was. This is another technology in the gaming space that was bought by Shuffle Master, the technology. Currently, I'm working on some very complex mechanical devices. This is an electronic compressor that's used in e-vehicles. This is a product or a device that's used in the assembly of microprocessor or semiconductors. But I also work on some much more simpler devices. This is a recently issued patent that I did that was on a birdhouse. All right, so let's talk a little bit about the different types of intellectual property. We have trademarks, copyrights, patents, and trade secrets. So what are these? Well, on a high level, let's identify them. Trademarks are used to indicate the source of goods or services. They can be a word, a stylized word, or a logo, or a combination thereof. And they are used to indicate the source of goods or services. Copyrights are used to protect creative works of authorship from copying. Patents are used to protect a patentee's inventions, and they provide a monopoly to practice the invention for a limited time. And we'll talk certainly more about each one of those. Trade secrets, they are used to protect secrets. And there's some definitely pros in using trade secrets, but there's some definite cons as well. So we'll talk a little bit more about each one of these. So trademarks, again, are words or designs that can be used to indicate the source of goods. They give you the right to prevent others from marking. In other words, using the same mark with similar goods or services. So there are some limitations on trademarks. You cannot stop other people from using your trademark truthfully. For example, that you cannot stop them from using your trademark in advertising as long as they're using it in a truthful manner. For example, they can compare truthfully again your goods or services with their own, and you can use your marks in that comparison. And again, you cannot stop others from using your mark with other goods or services that you're not using. So trademark rights originated with what is called common law. So they originated just by the use of goods, and it originated in unfair competition. So for example, if a company opened up a store on a particular street in a particular city, and they were there for 10, 20 years, and they had a good reputation and people associated with the name of the store with the goods or services that they were selling out of the store, then it would be unfair to allow somebody the street over or down the street or maybe within the same city to open up a competing store using the same name. So just through the use of that name in that store, you could be generating or obtaining trademark rights. But it's only going to be, your rights in that name are only going to be for the goods or services that you are using it with in that store. You can't use it or assert rights in that name with other goods or services. When you're choosing a name or when you're considering a name, generally potential trademarks, they may be characterized as one of the following. And these are not clearly defined categories. A potential mark or name is going to fit somewhere within one of these categories or between the categories. So we start off with generic, goes to descriptive, suggestive, arbitrary, and fanciful. Generally, fanciful can be, for example, logos that are made up or somewhat related to it, but they have some originality in what they look like. Marks that are generic, they're going to be very limited or no protection. So for example, if you're going to open up a store and you're going to sell bait and you call it bait shop, just from that standpoint. Okay, somebody has a question and we're going to talk about that, about marks that become generic. We'll get to that in a minute. So, so a generic type of mark is something that describes exactly what your, what product or service is. So example, the bait shop, or if you're selling chairs, and you want to call your company the chair company or the chair store, those are not strong marks and you're going to get very little or no protection in the marks. But you can go down that list and you kind of give some descriptive names about your goods or services. And for example, if you call your store the cheap bait shop, that's a little bit more descriptive, or the comfortable chair company. Again, those are very descriptive, and you're going to get very limited protection or rights within those marks. All right, so then we go down to suggestive and arbitrary and fanciful. An example of arbitrary, a well-known mark, is going to be Apple. Apple, the company, sells consumer electronic goods, and the name Apple, or the word Apple, originally had no connection to the types of goods they sell, but so therefore it's actually kind of arbitrary related to those goods, so that's a good mark. here we go. So trademarks can become generic. And what that means is if everybody starts using that mark or that name as a substitute for that goods, over time it can become generic, and the trademark owner's rights in that good disappear, and anybody can use it and they can't stop anybody from using it. I'll go forward just a second. So here's some marks, some well-known marks that different companies have protection in the US or other countries, and they over time became generic. So how do you stop goods from becoming generic? Well, you got to use the mark correctly. Use it as an adjective. So you're going to have, Apple is going to sell Apple computers, Apple cell phones, Apple tablets. You never use it as a noun because that's a good way for the mark to become generic. And as a company owner or a trademark owner, you must police your marks. So what does that mean? You must search for, monitor other people's uses of your mark. And if they're using it improperly or they're attaching it to goods or services that are not yours, to their own or other people's, you need to send them a letter, a cease and desist letter, telling them to stop using it that way. Or even if they're using it in relation to your goods or services, but they're using it improperly, for example, as a noun, you need to police it and tell them to use it correctly. What is a copyright and what does it protect? Well, again, what I mentioned before is a copyright protects original works of authorship. Examples are novels, plays, songs, software, photographs. It gives the copyright owner the exclusive rights to copy the protected works and allows you to prevent other people from copying it or making modified versions of the work. So what does require copyright or copying for infringement? If there's no copying, then there's no infringement. So if somebody just independently creates a similar work or takes a similar photograph, if there was no copying, if they didn't have access to it, they didn't know about it, then there's no copyright infringement. That answer, I do not have an answer to it, that question. The question was, did Kimberly-Clark and Johnson & Johnson try to enforce their marks for Kleenex and Band-Aid? I don't have an answer on what efforts were made. So moving over to trade secret protection, what does it protect? Any type of information that is secret can be protected by trade secret. So examples are formulas, compositions, methods of manufacture. But the trade secret owner must take steps to keep it secret. So if they just leave it running around, or anybody, if it's lying in somebody's office and there's people that are not employees, suppliers that come in and out of the office or the plant, and they don't take steps to protect it, then trade secret protection may be lost, even if somebody had obtained the trade secret information from the company improperly. But if the company didn't take steps to protect it, then it may not be protected. As I mentioned before, there are certain pros and cons with trade secret protection. The pros are that as long as it's kept secret, it can last forever. There is no time limit on trade secret protection. There's also no subject matter restriction. So any information that is that is secret and is protected can be subject to trade secret protection. For example, customer lists, which is just a list of customer and contact information, may not be protectable by other types of intellectual property, but as long as they're kept secret, they can be subject to trade secret protection. The cons are it only protects from theft. So again, you have to keep it secret, but it doesn't protect from some competitor independently developing the same information or reverse engineering it. So if you have, for example, a composition in your product that somebody can reverse engineer from and once the product's out in the marketplace, reverse engineer, then it loses its trade secret protection. What is a patent? Well, a patent is an exclusive grant to the innovator, the inventor, that results from a bargain between the federal government and the innovator. There's a scope of rights that are defined by the claims of a patent, and whatever the claims, whatever the scope of the claims, it gives the patent owner the right to exclude others from making, using, selling, offering to sell, or importing technology protected by the patent for a limited period of time. It's not a right to practice the invention. It's only a right to prevent other people from practicing. There are, again, there's a period of length of those exclusive rights. For a utility patent, it's 20 years from the first filing date, and for a design patent, it's 15 years from issue date. And we'll get in a couple examples here in a little bit. Let me mention this. So what I mentioned above is that it's a result of a bargain between the government and the innovator. So the government is granting the patent owner this limited monopoly for a limited period of time, and what the inventor or the patentee is giving up is they must tell everybody within the patent document, which becomes public when the patent is published. They must tell everybody how to practice the invention. So they must have enough information within the patent document to enable somebody else to practice the invention based on it. And there's a couple of reasons to do that. During the term of the patent, everybody must know what they're not supposed to practice. So it's defined, that scope is defined by the claims, but to properly understand the claims, you must tell everybody exactly what you're doing. And after the patent has expired, you are in essence giving that knowledge to the public for people to freely use. What can be patented? Any process, machine, article of manufacture, or composition of matter that is useful, novel, and non-obvious. So what does those mean? Well, most things are going to have some use. It's really not much of an issue in the US at least. Novel and non-obvious, those are two patentability standards. They are generally, okay, let me get to that. I'll get to that question in a second. When you file a patent application, you file it at the patent office, and it's going to end up in front of a patent examiner. And the examiner is going to compare the claims of the patent with what we call the prior art. And prior art is basically, you can think of as any public knowledge that is available before your filing date of your patent application. So the two standards are of novelty and non-obvious relate to the comparison of your patent claims against this prior art. And basically, just think of it as anything. The novelty standards are the elements of your patent claim, can they be found in a single piece of prior art? And if they can be found in a single piece of prior art, then they are not patentable because they're not new. And even if they're not found in a single piece of prior art, if there are two or more pieces of prior art that have all the elements of your patent claim, and there is some reason to combine it, whether they're the same type of product or there's some suggestion to combine them, then if all those elements are found in two or more pieces of prior art, then the invention can be found to be non-obvious. So let me address this claim or this question. If a patent is being infringed, a cease and desist letter is presented and the infringer continues to infringe openly after being warned, what further legal action can be taken? Well, you can take steps. You can obviously just file a lawsuit and serve them for patent infringement. Obviously, there's a lot of due diligence you want to do before that. But prior to filing a lawsuit, you can file a lawsuit but not serve it, and you can provide that in a letter. Saying, hey, look at it. Try to bring them to the table to negotiate. But other than, if they're not responding to your letters or to that lawsuit being filed without it being served, then you're going to have to serve it. Next question, is an algorithm or software patentable? That's a very good question, and there's not an easy answer. I would say that applications of algorithms or software, mostly, algorithms mostly embodied in software, um, or can be embodied in software applications. So what is the software doing? What machine is it running on? It can be very, very difficult if I have a piece of software that is running just on just on a single computer without any interaction with other computers or other devices. But if it's running just on a single computing device, it can be very, very difficult to get patent protection on it. We can talk a little bit about it, but while if you have a piece of software or you have some other invention, it can be, these types of intellectual property are not mutually exclusive. So you might be able to get on a single product, you might be able to get a design patent, you might be able to get a utility patent, and some aspects of it may also be protectable by copyright. All right, a little bit more about the types of a little bit about the types of patent applications or patents. There's a utility patent, design patent, and a plant patent. Utility patents protect how an invention works, the combination of elements that are necessary to work as intended. And a design patent only covers the aesthetic elements of a new device. So, for example, a bottle or a chair, if those have some aesthetic elements, then they could be potentially protected by design patent. In a design patent, you have a single claim, and it's defined just by the drawings or the figures within the patent. So if you have a bottle, your claim is going to read something like a bottle as shown in the figures. Utility patents are more based on words and the elements that make that invention work as described by those words. That's what protected, and they have to be, whatever the scope of that claim has to be, meet those standards, new and not obvious. The question here is, did ChatGPT get patented? And I'll be honest with you, I don't know the answer to that question. So there's my guess is that there may be an attempt, but there might also be, they may also want to keep some of that to be trade secret. I don't have an answer for that. I will tell you that in the past, in my own practice, I did file a number of applications, patent applications on search engines, and to the extent that those, or in e-commerce, to the extent that those methods or systems had an interaction between more than one computer system, that's where you got to go to. So there's certain things that you can go, how you address the claims that can make it patentable. So in terms of the types of inventions that can be protected, and that's beyond the standards of new and not obvious. All right. So for startups and new companies, or for all companies, one of the things that you really have to be careful about is or aware of is that you need to make sure that you secure the ownership of all the intellectual property. So intellectual property can come into a business in different ways. Typically, people think about, well, it's the employees of the company that create intellectual property. You have designers, you have engineers, you have software writers that they were hired to do a certain job and to create certain types of intellectual property. So most companies are going to have employee agreements that all employees sign when they're onboarded to the company, and it transfers ownership of any intellectual property that is generally created during or for their employment over to the company. Other ways that intellectual property can come into a company is when your company is formed. One of the owners or the the partners in the company, they may bring intellectual property. They may already have the idea and they're going to bring it into the company. So as part of the documents that are created when the company is formed, that ownership needs to be addressed, whether or not it's going to be now transferred into the company as part of that partner's or that owner's contribution to the startup, or if it's going to be just licensed or so that company can use it. That all needs to be addressed at the startup. The more troubling one can be that if you hire a third party, or a third party is going to create intellectual property for you as a favor because it's a friend, right? Well, that can cause huge problems because the ownership of that IP, even if they say, I'm going to transfer it over to you, may not have been effective. So there has to be, whether you're paying, there has to be, in any agreement, there has to be consideration, meaning each party has to bring and exchange something to the agreement in order for that agreement to be effective. So typically, if you're paying somebody, that's that person's consideration, and then they're going to give you something in return, whether it's software or some design. Well, you want to have a written agreement that moralizes that and actually affects the transfer. So it can be very, very tricky, for example, in copyright, where the law requires a written signed agreement between the parties in order for that transfer to be effective. And several times in my career, I've come across, I've had a client that hired me to develop their patent portfolio. And prior to me being involved with allowing it, there was a person involved in a couple situations where they did not inform me of this third person because there was, say, a piece of software, an early piece of software or a prototype that was developed, and in their view, they stopped using that piece of software, and therefore the person was an inventor. Well, once that company becomes successful and starts generating money, this person comes up and says, hey, I should have been named as an inventor, even though you're not using my software code. What I invented is embodied, and they had to defend against that. So we have a question. What is the best way to protect the patent asset? Can it create a holding company that owns a patent and licenses it back to the company that will manufacture the patent product? The answer to the second question is yes. A lot of companies do that, and it really depends on. This is not necessarily my area of expertise. It goes into company formation and sometimes taxes, but you can do that, and it can happen if there's kind of a complex ownership of the company, and maybe whoever owns the intellectual property does not necessarily want to give it all to the company. Maybe they want to bring in different investors that are part of the manufacturing and the sale of the goods, but don't have an ownership necessarily in the IP itself or the patent. So the answer to that question is it depends. So the first question. So at this point, I'm going to run into kind of a very simple hypothetical. Are there any questions before we move on?
There are any questions in the room? One second. All right, no questions in the room yet. I'll field those as we make them around. But we do have from David, and appreciate you, Jim. It's made my job real easy for you to look at the chat. But I'll field one here from David. What do you think about the inventors writing their own patents and suggested claims, then turning it over to an attorney? I guess, are there benefits to this? Are there pitfalls with this? And can you elaborate on?
Sure. Well, as this is, as that's what I do for a living, I would highly not recommend it. But just on that standpoint, but I would say that there are certain pitfalls to doing that. I've taken over a number of patent applications where the inventor did exactly that. And one of the reasons they do that is when they get a first examination report from the examiner, it will tell them, you need to hire an attorney to help you out with this. And part of the problem can be, one is there are certain standards both in drafting the application or filing the application that need to be filed. We talked about there has to be enough information to enable somebody else who's skilled in the art. And there are certain things that we do when we're writing the application to make sure that those kind of standards, may not have, all the technical knowledge that the inventor has, but we can, basically work with the inventor to make sure that those standards are met. The other thing is the claims are very legalese. If you've ever tried to read a set of claims, it's very, very hard to necessarily understand them from a layman standpoint. But there are reasons that we write them in a certain way for doing so. And I see David wrote that attorneys prepared the final filing. So I have done that in the past for certain clients where I've worked with before, and I know they have a certain level of knowledge and they've done this before. But I will refuse to do it for other clients because even if even if I'm preparing the final filing, I am putting my name on it and filing the application. And if it doesn't meet certain standards, then I'm opening myself up to potential, lawsuit for malpractice. So I would have an issue with that.
No additional
All right.
questions from the room, right? Oh, you know what? One sec from Maggie. Jim, can you also address how an investor might feel about investing in a company that is utilizing a patent, but the inventor has put it into a holding company? Ooh, that's a good question. We do see that often. They have the patent, but it's in a holding company.
Yeah, that's certainly something that needs to be. It is a great question. It is something that needs to be addressed and can affect the level of investment because obviously they want to they want to get a return on that investment, and it's just something that needs to be addressed, and everybody has to make sure that they're upfront about what's going on. There may be reasons to do it. Sometimes a patent may have broad applicability that is broader than the subject of the company that's manufacturing a product. So it might be, there might be intellectual property on a method of manufacturing or a composition of matter that's going to be used in a specific product, but it can be used in a lot of different products. And so if an IP owner of a holding that they put the IP within a holding company wants to just have a company that does a specific type of product, but they want to be able to license that IP to other in other industries, that might be a reason to keep it in a holding company as opposed to the manufacturing company. But it's just a matter of, again, it's something that the investor has to do their due diligence and understand where that's coming from, and it might impact their level of investment. Another good question. Okay, so is it okay to create a provisional patent application without a lawyer, then later use a lawyer for the non-provisional patent? So yes, I get a lot of times, I get clients that come to me and they want to file a provisional, and they want me to file the provisional because we can electronically file it. We put it in our docking system. We monitor it, and we give the client reminders about when they need to start preparing the non-provisional. The risk is when you do that. So I've had it where clients have filed the provisional and then they contact me because they want to write the non-provisional, or they say, hey, here's my documents. They want me to file it as a provisional. The risk is that we don't always know what is, at the time you file a provisional patent application, you don't always know exactly what's going to be patentable, what features or combination of features of your invention are going to rise to the level of patentability. And whatever those are, they have to be fully disclosed and enabled within the provisional application in order for you to get the benefit of it. So while it's not as risky as having the inventor or the patent owner file or write the non-provisional, there is some risk that it doesn't hasn't really described all the elements of the invention. Okay. So when a client does that, if they come to me and say, hey, here's we want to file a provisional, and what I generally do is I do offer a different levels of service when it comes to that. So if they understand the risks, I will file their documents as a provisional patent application, charge them a flat fee, and that enables us to docket it, communicate with the patent office, and to give the client reminders about what it is. But I will also offer at least one additional level of service in which I review that application and I provide them direct feedback. Exactly, hey, this is the type of information where I see there's holes. Here's what I would add to it. In fact, I just gave a client back a document today that had a bunch of questions and a bunch of comments about their disclosure document, about what information I think needs to be added to that application before it's filed as a provisional. I also do add a different levels, a higher level where where I say, look, I will write it. I will rewrite your provisional or your document as a provisional application that looks more like a non-provisional application, and that helps flesh out, make sure we flesh out exactly what the invention is, and make sure we have the disclosure. So I generally, when I'm faced with that question, I'll offer two or three different options for the client. Yes, David. David said, can we send you a sample to see what you think of it? Yeah, absolutely. Tagline question. Yeah, taglines you can copyright. So I don't think, I'm not sure that I described or talked to this a little bit, but when you look at a trademark, or when you're looking at stuff online, you're going to see a TM, or marks indicated by a TM, or marks with a circled R. So if you see a TM, what that means is somebody's using a mark or using a word, and they haven't done anything official. They haven't filed not necessarily, they haven't obtained a federal registration, at least yet. But they think they're using a particular word as a trademark, and they're letting people know that, hey, look, I'm using this mark or this word or this logo as a trademark, and I may be accruing rights into that mark, and they're putting people on notice. So they may, you can put a TM on a generic word, and you might actually be accruing no rights into it, but you're telling everybody, hey, I'm using it as a mark and I might be accruing rights. If you see a circled R, then that means that somebody has attained a federal registration on that mark, and their rights are good across the country. So your question about taglines, I find, yeah, you can trademark and get a federal registration on taglines. Sometimes I caution clients where it may not always be that worth it. They can use the tagline, and they could put the TM so that they're putting people on notice. But if it's a long tagline, or maybe you're going to not use it in 6 months or 3 years, maybe just the common law, common law protection is sufficient, as opposed to getting a federal registration. But clients and companies do get federal registrations on taglines all the time. And in fact, I actually within this year, I got a registration for a client on somebody did it. I'm sorry, I misread the question. I did get a federal registration on a tagline with a hash mark this year. So yes, you can do that. Sorry, I read it as service mark.
Hey, Jim, it's Maggie.
Yeah.
Entrepreneur Magazine has either registered or trademarked the word entrepreneur, which is a noun.
Yes.
And they enforce it.
Yes.
But it's a word that's in the common lexicon.
I'm not familiar with their registration, but it is a noun, but the word is a noun, but you can use it as an adjective. So for that mark, it would be, I would caution a client or suggest a client, recommend that they use it as in Entrepreneur Magazine. So now it's an adjective.
Okay.
Okay, because their goods are not, they're not selling entrepreneurs, they're selling magazines.
Mm-hmm.
So Entrepreneur Magazine, that's an adjective.
Yeah, so up here in the north, there was a group called Entrepreneurs Assembly,
Mhm.
and they got a cease and desist letter from Entrepreneur Magazine. And they're like a little tiny organization that doesn't even have any way of making money. So what are they going to do? But
That that is a common problem where you have a big company, you have a big company or a large company that is just, for lack of a better word, abusing their marks,
okay,
and that
I agree with
happens a
that.
lot. There's, it happens a lot. There, the extremely popular sports league in this country has a similar reputation.
Yeah. Okay.
I don't disagree with you, Alex. I'm just looking at your comment. But it's companies go to extraordinary lengths to protect their valuable trademarks, and even if you think it's unfair or it doesn't, and this happens not only in trademark but also on patent law or with patents, that it can be expensive to defend against such an allegation. So a lot of times people fold. What is a patent troll and how can you defend against them? So a patent troll is a better term is probably what's called a non-practicing entity, or somebody that is just obtaining patents in order to force them to force companies to pay a nuisance licensing fee, thinking that it's not worth it to defend against it. How can you defend against it? Successful defense. Successful defense. One way to do it is you can come up with if there are other companies, even competitors, that are faced with the same allegation of patent infringement, you can enter into a joint defense agreement. So even if one company, they're asking for some relatively, in their minds, small license fees that they think somebody's just going to pay because it's not worth the nuisance to fight it. But if enough people get sick of it, so to speak, then they can sign a joint defense agreement in which they kind of pool the resources, pool their efforts to kind of defend against that allegation. David's asking a question of, can you discuss efficient infringement? And I don't know what that means. So maybe David, you can elaborate on what you mean by that.
Oh, I think David means, sorry, I had a hard time unmuting my mic. Is there a way, what are the ways that you can efficiently, to streamline the costs of defending a patent? And are there ways that you would suggest?
Defending an infringement litigation? Or
I believe so. I think what David's trying to say, if someone is infringing on your patent, what are some of the cost? Are there any cost-efficient ways to defend that you recommend? Or, a phrase another way, sometimes we recommend is there a way for you to find out quickly without spending too much money if you have a chance in hell?
Well, okay, so I think there's two. I think so. If you're a patentee and you want to assert it, it can be obviously very expensive to assert or go through litigation. So there are companies that will invest in that. They will fund that litigation in exchange for a portion of the proceeds if it bears out. Cost too much to defend. So that's the opposite question. So if you're in an industry that is very litigious, and there's a company that owns a lot of patents, and they infringe everybody, you can get insurance. You can get patent infringement insurance. Willful infringement. Okay, so that's a different topic. So willful infringement means that it is if there's patent litigation and the infringer loses, then the patentee side, they can move for make an assertion that the company or the infringer willfully infringed. And that basically means they knew about the patent, they knew they infringed, and they continue to infringe anyways. And if the court agrees with that and finds that this is after a trial or after a finding of infringement, and then the court finds that the infringer willfully infringed the patent, the court can impose a tripling of the damages on the finding of willful infringement. There are ways to defend against it, but that's what willful infringement means. So David, I think you're asking like 3 different questions here. I'm not sure if I've answered those. Stacy Electronics 1, Stack Electronics 1 against Microsoft Double Disk. Okay. So if there was a finding of willful infringement, so in a jury trial, the jury returns what they think the damages are for that infringement, and then the judge can decide after motion and a hearing on the motion, they can decide whether or not the infringer willfully infringed, and then the judge can triple the damages that the jury gave or found. All right. So I just wanted to quickly run, if there's no more questions, through a couple of issues that came up. It's just a very simple hypothetical. We have an inventor. He invents 2 new chairs, and he wants to start a company, and he wants to sell the chairs online or in a store. And as part of that, he needs to have a third party complete the design for manufacturers. So some of this kind of just pulls in some of the stuff that we've already talked about. All right. So again, this new company, the company may want to investigate all these type of intellectual property. You potentially want to seek patent or trademark protection, or consider what your trademark protection would be on the company name or the brand name for this line of chairs. You want to choose something that's further down the line than generic or descriptive. You may want to consider a design or utility patent protection. There may be some copyright things that can be protected by copyright, and maybe there's some stuff that lends itself to trade secret. Just some examples, of hypothetical or possible names or that process. I do get a lot of clients that ask, come to me asking for trademark protection on generic names. I'm always surprised, but I always tell them, choose another name, even if it's very descriptive of not generic, but very descriptive of what the goods or services. I try to lead them down, hey, look, choose another name, choose something that's a little bit more arbitrary. And before you invest a lot of money into a name, I do suggest that you search the name, at least on the internet. You can also do a search or have a search performed on the Federal Register of federally registered marks. And the purpose of that is you don't want to start, marketing your product, invest time and effort into a name in which, 6 months or a year down the road, there's going to be somebody recognizes that, or has rights into a very similar name, and then you get a cease and desist letter. And you can either begin using the mark with the TM, and or file a federal registration for the mark. And up until you actually obtain the certificate for the federal registration, you can always continue to use the TM as opposed to the Circle R until you get that certificate. All right, if you when you're designing the chair, if we're designing the chair, if you're using employees, when you're onboarding new employees, you should have an employee agreement that makes sure that any rights of anything that they invent or create is transferred over to you. If you're using a third party, for example, completing the design for manufacturing purposes, you need a signed agreement transferring the rights over. And I think David or somebody else asked about, doing it yourself. I would advise seeking advice from a patent attorney. Just a quick example, this of a design patent. This is actually design from a design patent that issued in 2008, and it's one of the figures of the chair. And as I mentioned before, a design patent has a single claim that basically say something like, "We claim the chair is shown in the figures." So it's really based on the way the chair looks. If it has a feature or a functional feature, it's not protected by the design. So moving to a different chair, this is an example. This one's from 1899, and basically this is a utility patent that the chair seat rotates or moves in the direction of those arrows. And this is actually the claim, the words of a claim from the patent. So you have these elements: a chair frame, an independent tilting seat, these supporting blocks, which are shown in green, and the supporting rest in yellow. So when you look at the difference between a design patent, this design patent covers chairs that look like this, even if it doesn't function the same way, if there's some moving parts, for example. But then your utility patent would protect or allow the patentee to stop other people from practicing any chair that, no matter what it looks like, if it has these elements. All right. So just going back to our hypothetical, these are the type of things that can be protected by copyright in this new business, and potential trade secrets, manufacturing methods, the composition of maybe some of the chair components, as long as they're not easily reverse engineered. Again, they have to remain secret, and you have to they have to remain secret, and somebody doesn't protect from somebody independently developing it. So that ends my prepared slide. So if there's any questions, I'd be happy to answer them.
Excellent, Jim. Spectacular. Really appreciate it. We have a comment from David. Very useful presentation. So again, thank you for presenting. And this is really a topic that a lot of founders kind of usually need quite a bit of guidance on. So really appreciate your time. We'll field a few more questions for those that are online. Please put those in the chat. Maggie, you've been having some good commentary on this. If you have any additional ones that we see from founders often, please put those in as well, or tune in. Any from the room at all? All righty.
So Logan, yeah, I popped in at the same time that David wrote his thank you. Can we use photos that are copyrighted if we include the copyright in the presentation?
Absolutely not.
Okay.
So that creator wants to be compensated. So that you cannot use it even if you attribute it. That would be a violation of their copyright. So I know a lot of people do that. Hey, I need an image, and let me go find a picture or some graphic on the internet, and I'll just use it. Well, strictly speaking, you can't do that.
Where they have agreed to allow you to use them, like Unsplash and
sure,
Pixel something, yeah.
Sure. If they're posted and for that purpose, or you have you get them through some subscription of images or whatever, as long as you comply. Now, normally it's not a transfer of that ownership. It's a limited license. So maybe the license is for non-commercial purposes, or for educational purposes, or for personal purposes. That means you can't start selling mugs with that picture on it, right? That's not, that's outside the bounds of whatever that license is.
Okay, Jim, we have a question from in the room. Do all claims need to be satisfied to get a patent? Actually, they just put it over the chat as well. Actually.
Do all claims need to be satisfied to get the patent? I'm not sure what that necessarily means. So when you're talking about a utility patent, if we go back to this example, okay. So this is I mentioned in a design patent, there's a single claim in a design patent, a chair that, as shown in the drawings or the figures, right? So, but in a utility patent, there can be more than one claim. There can be, actually, there's no limit as long as you're willing to pay for them. This is a single claim. So if the claim says a chair that has these elements and it doesn't refer to another claim, then it's called an independent claim. So a dependent claim would be something like, if this was claim 1, a chair as set forth in claim 1 that has a padded seat. Okay, so it's adding some limitation. That's a dependent claim. So I'm going to have a series of dependent claims in a utility patent, and most likely more than one utility patent. So every single one of those claims, when you're looking at patentability, in terms of, is it different enough from the prior art, at least the independent claims, because those are the ones that stand alone, have to meet that standard. They have to meet the novelty and the non-obvious. If you're talking about infringement, all right, so if I have 3 independent claims, somebody only has to infringe one of the independent claims, and then they infringe the patent. So Matthew, I'm not sure if that answers your question, but if I have 3 independent claims that kind of stand alone, they do have different scope, they may have one or more different elements. So if I'm talking about infringement, an infringer only has to have all the elements of one of the independent claims.
Yeah, I'm going to get one of the mics to Matt in the room so he can add a little bit of context to that.
Okay.
Hi, yeah. So my question was around, if you have 4 claims in the patent, and the advisor or the person looking over the patent decides that only 3 stand up to scrutiny, will he throw the patent back and ask to redraft it, or will he allow the patent to be preceded yet?
So you mean the patent examiner? Right.
Exactly, yeah. Do you have to be careful what claims you put in to make sure that it doesn't get sent back to be rehashed?
So when you file a utility, you have a base filing fee, okay? And that base filing fee allows you to file up to 20 total claims and 3 independent claims. And almost all will have that. You can file more. So the examiner has to examine every claim. And I will tell you that majority of applications, the majority of claims in the first examination report, almost all the claims are going to be rejected. And there's a couple of different reasons for that. Okay. Normally is when you file an application, and David's right, his answer there, okay, is when you're filing the application as the attorney and you're drafting the case, normally the client is going to want you to get as broad protection as possible. So looking at the claim that's on here, right, is if that's a claim that's going to be examined and compared against the prior art, if your chair had 20 elements, we could write one claim that identified all those 20 elements, which may be theoretically easier to get because it's going to have a better chance of being new and non-obvious. But an infringer would have to just not include one of those elements. So we want a broad claim with the least amount of elements. So when you're drafting the case, you want to go in as broad as possible. And then your terms, the elements of those claims, they are going to be defined or by the specification, by the rest of the application. So when you're talking about what is a chair frame, you got to look to the specification. Well, what do you mean by the chair frame? How is it used in the specification? The examiner is going to take a very, very broad view or interpretation of those elements, particularly for that purpose, like David said. He's going to get you to do the work and tell you why your invention is different than the prior art that the examiner cites. And you can, if you need to, you can either argue and explain those elements, but you may also change or amend those elements to distinguish over the prior art. So all the claims in an application, in order for it to be allowed and issued as a patent, have to be different. But you have as many chances as you're willing to pay for to go back and forth and argue or amend those claims with the examiner to get to a point where the examiner agrees they're patentable. Now, the other thing I want to say is when you were talking about, getting, drafting the specification, when you're amending those claims, whatever language or element you're adding or feature that you're adding to the claims to overcome that prior art has to be in the application as it was originally filed. And if you want the benefit of the provisional application filing date, it has to go back to the provisional filing date. So if it's not in the provisional filing, in the provisional application, then you're only going to be able to rely on the filing date of the non-provisional. But again, either way, that whatever element or feature you're adding to distinguish over the prior art has to be within the application as it was originally filed. Does that answer your question, Matt?
Yes, it does.
Okay, great.
All righty. Any additional questions from online? David has a comment or a comment. So examiners are basically rejecting all claims to get you to do work. All right. Any questions out here? We have a question in the room. I'll go ahead and just put the mic to them. 1 sec.
If software or an algorithm is already in use, it's already been public or anything by another company, and you begin to use it, are you able to put a patent on something like that, even though it's already been out there?
No. The answer is no. So that would be if anything is public knowledge available to the public. And I don't mean the public can freely use it, but if the knowledge is out to the public and it's there before your patent application filing date, then it has to to be patentable, it has to meet those two standards. It has to be new and it has to be unobvious. Now, having said that, if anything, whether it's software or some physical device, if you're using something in a new way or in combination with something else that is new and not obvious, then it may be patentable. But if you're using it exactly the way that it's intended to be used, then it's not patentable. It has to be new and not obvious.
That's my question. Thank you.
One last point to David. David, examiners are basically rejecting all claims to get you to do the work. If you respond to an examination report only with arguments, sometimes that can, instead of changing the claim, sometimes that can convince the examiner. But the reason he's doing that is because that's part of the record, and whatever you say can be used against you later when you are asserting the claims. If you're saying, this element means this, even if that language of what it is not directly within the claim language, you are going to be limited to that.
We have an additional question from in the room from Matt. 1 sec.
I don't know if this has been covered already, but for provisional patents, when they expire, does that become a trade secret, prior art, or what's the status? Is it revealed to public knowledge?
Mm-hmm.
Or can you then go back later and file a patent on that same material?
So provisional patent applications, if you do not claim priority to in a non-provision, so if you just don't use it, then it remains secret, and you could potentially refile it, okay, without getting the benefit of the earlier filing date. So as I mentioned before, your prior art is going to be defined by your filing date. So if, let's say, because I've done this for some clients, let's say I file a patent application today, and a year from now, the client or the patentee hasn't made a decision about whether or not to proceed commercially with it, so they just let it die, and they change their mind 6 months, and so we refile it. So now, since you now filed it 18 months later, you're basically potentially allowing another 18 months of prior art to be used against you. So, and as you may recall, your own activities of public disclosing, those also now could become prior art. So in the US, if I start selling it or publicly disclose my invention today, I have 1 year from today in which to file a patent application. But if I file that patent application in a year, and then a year from then I don't use it and I want to refile it, my public disclosure of back to today would prevent me from getting patent protection on that particular invention. Now you would have to look at were there improvements, changes, that kind of stuff, and maybe you can get patent protection on those. But your public disclosure now, 18 months or 2 years before your second provisional filing date, can be used against you.
Okay, from David, this comment. If a filer is over 65 years old, their application goes to the head of the line. I didn't know that. I don't know. Can you confirm that?
I can. I had a client that I did work for 20 years ago, and I think it was last year. Yeah, I think it was last year. Contacted me, and we filed a petition to advance. Those type of petitions are automatically granted. There's no guarantee on the exam, when it will be picked up. It does kind of depend on the examiner and what their workload is. But I will tell you that patent issued 2 weeks ago. It went through two, and that was through two examination or what we call office action, and then we responded to them, and it issued last month. So yes, that is true.
Okay, I didn't know that. Cool to know. Are there any additional questions from online or in the room at this point? All right, Jim, thank you so much again. This is definitely a topic that needs a lot of technical expertise, and it's great to have some of the best come in and speak to our attendees. We will have a recording of this session available for the attendees here and on our platform available by the end of the week. Jim, are you okay if we share these slides, or do you want? We usually have people asking about the slides. Do you prefer to retain those? Or do you have a version of these slides that we can share?
I emailed to Maggie, so she already has them. So please feel free.
Excellent. Jim, if people want to find you, hear a little bit more about your services, can they connect with you on LinkedIn, or should they follow Endurance Law Group? How would they go about doing that?
You can follow. You connect with me on LinkedIn. You can do a search for Endurance Law and contact me directly, however you want.
Excellent. Jim,
I am here in Vegas on Pacific time, so please feel free.
Excellent. Jim, again, thank you so much. Thank you, everyone, for joining us today, or excuse me, tonight. We will see you. Next week is Thanksgiving week, I believe. So we will not see you next week. But after that, Maggie, do you recall what our next session is in 2 weeks?
I think in 2 weeks, it's our first pitch practice in deconstruction.
Okay.
Wait, it's December 5th.
Yes.
Yeah, so now during Startup Week, we're having pitch practice. Then the following week, we have Faye talking about investments or something. And then our last session of the year on the 13th will be another pitch practice.
Okay. So team, I do want to emphasize the best thing you can do to improve your pitch, if you've never pitched, to try that, is to get out there and do it. So we will provide some opportunity for you to do that. And of course, get some critical live feedback for your pitch. So please tune into those. Don't skirt around it. If you guys, it's highly recommend you participate on those during those sessions. And of course, we'll have Faye Almashon to talk about the 101s of approaching and communicating with investors. I believe it's her session. But everyone, have a wonderful Thanksgiving week. And then we will see everyone here for the Las Vegas Startup Week from the 27th through the 1st. And yeah, take care of yourselves. Drive safe if you're in the room, and take care.
Stay off the roads. Yeah. Thank you, Jim.
You're welcome.
So great. Really appreciate it.
Have a great evening, everybody.